Imagine you've just received a letter from your landlord. Your stomach drops. What does it say? Are they putting your rent up? Are they trying to evict you? Are they telling you to get out? If you're one of 11 million private tenants in England. The Renters' Rights Act 2025 just changed your tenant rights forever. And in this video, I'm going to tell you exactly what that means for you and what your landlord doesn't want you to know. Stay with me until the end, because some of these rights will genuinely surprise you. Imagine you've been the perfect tenant for 3 years. You pay your rent on time. You look after the property. You've never caused a single problem. And then one day, out of nowhere, your landlord hands you a notice. No reason given, just get out within 2 months. That fear, that powerlessness, is something millions of UK tenants have lived with for decades. Under the Housing Act 1988, landlords could do exactly that. It was called a Section 21 notice, a no-fault eviction. But here is the thing. That notice is now illegal. The Renters' Rights Act 2025 abolished Section 21 completely. Landlords must now use Section 8 grounds instead. The two most common are Ground 1A, if your landlord wants to sell the property, and Ground 1, if they want to move in themselves. And crucially, they must prove it. Fixed-term contracts are also gone, replaced by open-ended tenancies that roll on indefinitely. That means no more being forced out just because your 6-month contract ended. Your home is now yours for as long as you want it, as long as you pay your rent and look after the property. This is the single biggest protection UK tenants have ever had, and organisations like Shelter and Citizens Advice have been campaigning for this for years. Imagine you have a pet, a dog, a cat, maybe even an XL bully like my Max, and every time you look for somewhere new to rent, you hit the same wall. No pets, no pets, no pets. That is about to change for private tenants in England. Under the Renters' Rights Act, you now have the legal right to request a pet. Your landlord must respond in writing within 28 days and cannot unreasonably refuse. Now there is a loophole, and I covered this in detail in a previous video. Landlords can still screen out pet owners at the application stage before a tenancy starts. The protection only kicks in once you are already a tenant. But once you're in, you have real legal teeth. If your landlord refuses unreasonably, you can take them to the first-tier tribunal. That is a huge step forward for UK tenants with pets. Imagine waking up every morning, and the first thing you see is black mould spreading across your bedroom wall. You've told your landlord 3 times, 6 times. Nothing has happened. I know someone who lived like this, with 2 young children, for years. She didn't know she could do anything about it, but she could, and so can you. A 2-year-old boy called Awaab died in 2020 because his landlord ignored mould for 3 years. His death led to Awaab's law, which now covers private tenants in England. Under the Housing Health and Safety Rating System, once you report damp or mould to your landlord in writing, they have 14 days to investigate. If it's a serious health risk, 5 working days to fix it. A genuine emergency, 24 hours. And if they can't fix it in time, they must pay for you to stay somewhere else. Local councils can fine landlords up to £40,000 for serious breaches if you have mould, damp, broken heating, pests, or electrical hazards in your home. Report it in writing today. You now have the law behind you. You now have the law behind you. Imagine opening a letter from your landlord. Your rent is going up by £300 a month, starting next month. That feeling of complete powerlessness, of having no choice, is something millions of private tenants in England have experienced. But under the Renters' Rights Act, that is changing. Landlords can now only increase your rent once per year. They must give you 2 months written notice using a Section 13 notice. And here is the part most UK tenants don't know. You have the right to challenge that increase at the first-tier tribunal if you believe it's above the market rate. The tribunal will look at what comparable properties in your area are renting for. If your landlord is overcharging, the tribunal can reduce the increase. Shelter and Citizens Advice both have free resources to help you challenge a rent increase if you need to. If your landlord has been ignoring your complaints for months, you know something needs to be done. But the thought of going to court, the cost, the stress, the time, feels completely overwhelming. I hear this from so many UK tenants, and that is exactly why the new Private Rented Sector Ombudsman matters so much. For the first time, all private landlords in England are required by law to join a government-approved ombudsman scheme. This gives you a free, independent way to raise complaints about your landlord. Without going to court, you can raise a complaint, have it independently investigated, and your landlord can be required to pay you compensation. This is a massive shift in the balance of power between landlords and tenants in England. Imagine being able to check, before you even sign a tenancy agreement, whether your landlord is registered, compliant, and accountable. That is now possible. From 2025, all private landlords in England must register on a government database called the Landlord Portal. Landlords who fail to register face fines of up to £40,000. Why does this matter for you as a tenant? Because it creates accountability. Rogue landlords can no longer operate in the shadows. The portal brings transparency to the private rented sector that has never existed before. So here is what I want every UK tenant watching this to do. First, know that these tenant rights exist. Most landlords are banking on you not knowing. Second, report everything in writing. Text, email, letter, always get it in writing. No paper trail means no proof. Third, if your landlord ignores you, contact your local council's environmental health team, the Private Rented Sector Ombudsman, Shelter, or Citizens Advice. All of these organizations exist to help you. I'll put all the links in the description. And I want to say something directly to you. If you are watching this because you are going through something difficult with your landlord right now, I see you. I know how stressful and overwhelming it can feel. To feel like you have no power in your own home, but you do have power, more than you ever had before. The Renters' Rights Act 2025 exists because millions of UK tenants just like you refuse to be ignored. Use it, know it, share it with everyone you know who is renting privately in England. I started Tenant Power UK because I believe every private tenant in England deserves to know their tenant rights. In plain English, the Renters' Rights Act 2025 has given UK tenants more power than we have ever had, but that power only works if you know it exists. If this video helped you, please share it with every tenant you know, and if you want to go deeper on any of these rights, I've covered Section 21 no-fault evictions, Awaab's law, and renting with pets in detail in my previous videos. Subscribe to Tenant Power UK, because every week I'm breaking down exactly what your rights are as a private renter in this country.